Hello, everybody. My name is Bao Tran. I am a patent attorney, and I'm here with inventor Turner, who came up with the Turner Breast Shield. Mr. Turner, would you kindly explain your journey and your invention and your journey?
Sure. Morning, Mr. Tran. I'm a mechanical engineer by trade, and my wife, who is a registered nurse, lactation consultant, board certified lactation consultant, came home to me some time ago and said, "You need to invent a something where the breastfeeding woman can lay down in a more comfortable position, reclined position, and be able to express their milk through a breast pump." So I came up with the Turner Breast Shield, and Mr. Tran was quite frankly, a genius in helping me get through the process here. And we have several patents. You can go on and do a Google search. You can type in Turner Breast Shield, and you'll see the patents actually come up. So my journey was slow at first. I invented a prototype, and actually had a working prototype that I could explain the process to an attorney. My first attorney I was not very impressed with, and I spent a lot of money with him, and which was the unfortunate part for he talked big, but he didn't deliver any results. It was terrible. And he was in Southern California. I won't mention his name, but then I found Mr. Bao Tran on the internet, and I was very pleased with his process, with his energy, with the way he did things with me. He was always on time with calls. He asked me, one of the important things he asked me about the meeting with the patent examiner. He said, "Were you involved with the meeting with the patent examiner?" And I said, "The other attorney never wanted me to include myself in the meetings." And I would just get this feedback from him that we're working on it and things going to work out. And I was being driven down the wrong road, so to speak. Anyway, getting back to the invention, is the Turner Breast Shield. You can look it up on the internet. And we've got several patents working. And it's a breast shield that I made that you could express your milk, and it would the tubing on the side of the breast shield with a one-way valve. You would be able to collect your milk in a bottle and whatnot. Anyway, with that said, it's very important to involve yourself with the patent examiner meetings, which are very important. Because a lot of times the verbiage that you want to get across to the patent examiner. But anyway, I cannot recommend Mr. Tran any higher than what I'm saying to you here today. I highly recommend him. I like the way he took control of actually the patent examiner meetings, because the examiner on several occasions was confused what we were trying to get across. And Mr. Tran eloquently explained to the examiner, this is the process.
Thank you so much, Wayne, for your appreciation of our work. Now that you've gotten the first patent issued last year, we noticed that in the second case, the examiner is well educated, and he's practically granting you a second patent on the improvements. What do you see now as your next step in commercializing your invention?
Yes, so the next step will be I'm going to be putting together a 3D rendering. I've got the prototype and I've got a video, but I'm going to put together a 3D rendering, and it's just pretty much a detailed drawing with a sell sheet, the benefits of the device, etc. And I'm going to be presenting that to the industry. There are many companies out there. Medela is one, Amita is another that we want to present the invention to. And that starts another part of the process. But when you have a great invention which works and patented as well, and is protected, then you can feel free to present to the industry. In answer to the question, I'm going to put together a 3D rendering. We're going to put a sell sheet together, the highlights and the benefits of the device, and see where it goes in the industry.
Fantastic. That sounds like you're well on your way to licensing the industry on your invention, and we wish you lots of success.
Yes, and I might add too, Mr. Tran, that the wife, who is again a lactation consultant, has shown it to several of her friends, and describing, showing the video of the prototype in action. And they were amazed, and they said, "Oh my gosh, that's a home run. We cannot believe that the simplicity to the idea and what it will do for the lactating mothers who wish to pump breast milk."
That's the best testimonial. The simpler the invention, the easier to maintain, the lower the cost, and yet you've done it in an ingenious way. And we think that you're going to be hugely successful. So thank you so much.
Thank you. And then one other thing I'd like to add too, if I may. In doing all this, I asked Mr. Tran, will you help me with the possible licensing negotiations? And he was all for it. So I found a patent attorney who I just absolutely love. My wife looked at his work and loves his work, the detail of his work, the detail in the patent, and the fact that he's still on board with us when we negotiate any licensing contract. And I mean, he's very capable. And so we can't say enough about Mr. Tran. And we thank you, sir, very much.
Thank you. You've made my day. All right. Thanks,
Okay.
Wayne. Take care.
Thank you. Thank you.
Hello, today we will review how Mr. Wayne's application is reviewed at the US Patent Office. And here you'll see there's a serial number here, there is a docket number identifier, and then there's a title of the patent application. It was patented in August of 2023. So let's look at the history of the case. So the application was filed on March 21st, 2023 by a prior attorney. The applications include the claim, the specification, the oath, and then there's a petition to make special because of Mr. Turner's age. There was a filing receipt on April 6th. In May of 2023, Mr. Turner transferred his case from the prior attorney over to me, and there was a power of attorney here. In majority of cases, the examiner's job there is to reject the patent application based on prior art. So you'll see that right here. In June of 2023, there was a non-final rejection. So here we see a non-final rejection on June 23rd, 2023. The key to expediting the case is to respond very quickly. On 23, there was a rejection. On the 26th, we already have a response. So within 3 days, we were able to respond in 3 days because, number one, we worked diligently on Mr. Turner's case first. Number two, we were lucky that Mr. Turner was able to review and give us comment and feedback. As a result, we were able to file the response within 3 days. At the same time, we also requested a discussion with the examiner to make sure that everybody is on board. So we requested an interview, and we had the interview 2 months later. So this is just the delays caused at the patent office. On the 7th, we had the interview. We were able to convince the examiner that the case overcame the prior art, i.e. it was different enough from the prior art that he used. And so basically we received a notice of allowance on the same day, August the 7th. We paid the issue fee on the next day, August the 8th, and about 3 weeks. We receive an issue notification, and then from that issue notification, the patent office takes roughly a month to issue the patent. So it's September the 20th. So altogether, it took us 6 months from filing all the way to ones. And this is extremely fast because we respond to your cases very quickly. We would expect that you'll be available to help us. We also conducted the interview with the inventor present to provide this validation to the examiner that this patent is important to the inventor, number one. And number two, we raised argument that the inventor could elaborate on. So this collaboration resulted in a better work product and faster issuance. And that is the history of the application 18187-531 inside of the patent office. And this case ultimately successfully issued us patent number 11759554. We look forward to the same magic for your inventions. Thank you. Now let's take a look at a typical rejection of your application. In this case, we look again at the case of Mr. Wayne Turner. And here is the cover page of the rejection. It lists the name and the case serial number. Then as we scroll down, you'll see the first page is a summary of the office action. This office action is responsive to the application originally filed in March 21 of 2023. The original claims 1 through 31 are pending, and he objected to some text in claims 3 and 20 and rejected everything. The drawing, he accepted the drawings. Let's go to the detail office action. So basically, we submitted a prior art citation in what is called an information disclosure statement. So he accepted that. The specification, he considered it and indicated that claim 5 was rejected under section 112 because of indefiniteness. And so he indicated the reason why is that right here, this language is indefinite because the meaning of this limitation called a BPCE connection and opposite a milk container connection and a cap and a milk container is unclear. And he says, is the BPCE connection N is opposite a cap and a milk container, or whether the cap and the milk container were further limited. So we fix that by amending the claim. Then there's a rejection called a 102 rejection. So that rejection says that your invention is identical to another prior art. That means that every component of the claim is met by the prior art. And so he used this prior art called Silver, which is a publication called in the year 2011, and its serial number 0071466A1. And so he mapped each and every element of claim 1 into Silver, and he needs to do that in order for a 102 to be successful. This is contrasted with an obviousness rejection, which we will discuss later. Basically, he just mapped every claim to Silver reference. And so there are 31 claims and he just rejected every one of them. Then he goes into what is called a 103 rejection, or what is called obviousness rejection. So an obviousness rejection requires 2 or more references. In the claim, there might be a part of the claim is satisfied by one reference and part of a claim is satisfied by another reference. And so a 103 rejection would say these 2 references are in the same field, so somebody skilled in this area would have consulted both and would have known that this is obvious. So he recites some factor on obviousness under 103 by determining the scope of the prior art and then determining the differences between the prior art and the claims, and then you resolve that by somebody's skill in the area. So that's basically that. So in this case, he rejected claims 2 and 19 as obvious or unpatentable over Silver and another reference called Jaeger Waldau 2010 0049122. And he says that somebody skilled in the art would have known to combine because Silver does not disclose a soft plastic material or soft rubber material, and that Jaeger Waldau discloses a breast pump with a valve made from soft plastic and soft rubber, and so therefore combining the 2 would be obvious. Claim 4 was rejected over a different reference. So in this case, Claim 4 was rejected over Sherman and Jing. It's a Chinese patent application, CN 211068302. He mapped the combination here. And then basically he indicated claims 3 and 20 were allowable, so we were lucky in this case. And he gave his name and phone number so that we can call. So that's basically the rejection of the claim. So how did we respond to the rejection? What we did was to modify the claim through an amendment, and we added language wherein the ODB includes an adjustment tab and an adjustable sleeve having an adjustment slot. So that rendered the entire claim set allowable, because if claim 1 is allowable, then all the dependent claims are allowable. And ultimately, you'll see that that resulted in the allowance of the case when we talk to the examiner. Now let's look at the examiner's interview of our discussion with him. So he sends out a form called Applicant Initiated Interview Summary. So you want to initiate the call with the examiner because on their own they won't call you. In the interview form here we have the primary examiner me and inventor Wayne Turner, and then we discuss why we're different. The examiner will conduct a subsequent search before he'll reconsider his opinion. And we were successful in convincing the examiner that the case as amended is patentable, and that's ultimately allowed. So now let's look at the issue patent. It has the patent number, and it has the inventor's name, the date of the patent. It has the title in item 54, the applicant Wayne Turner in 71. The inventor is also the same. And it lists the serial number of the application as well as a filing date and then any continuation information. It'll list the references that was used in considering the patentability of the application. Then it also lists the primary examiner, Scott J. Medway, the attorney, agent, or firm. That the firm is PatentPC, and then the agent happens to be Bao Tran. That's me. And then it lists the abstract on the front page. If you go down, you'll see a representative image there. You'll see more drawings, and notice each drawing has numbers that then are used to discuss in the text. Then you'll see that the major parts would include the field of the invention, the background of the invention, the brief summary of the invention, and then the detailed description, where all those numbers in the drawings, they're all described and interrelated so that somebody skilled in the art would know how to implement the invention. And then last but not least, you'll see the claim. So here's a claim 1, and is an apparatus claim right here. Claim 12 is a method claim, like a recipe. And that's the issue patent. And then from now on, Mr. Turner can license and talk frankly about the invention. So we wish him good luck in making lots of money from his invention. That's the whole point of the patent system. Thank you, and we look forward to working with you. Hello, this is patent attorney Tran, and today we will talk about the patent to Mr. Wayne Turner that I had procured. So this patent is US Patent 11759-554. It issued on September 19th, 2023. And the title of that is called Breast Shield with Suckling Motion One-Way Valve. And this is a novel invention to make it easier for nursing mothers to be able to extract milk better. If you look at it quickly, there is the title here. Then you got the applicant and the inventor. And if you scroll down, there's the priority date and the application number 18187531, and it was filed on March 21, 2023. We were able to expedite the allowance of that case because it issued within 6 months of filing. So that's extremely fast. On average, a patent application issues in 2 years or more. If we scroll down, we're going to see the international classification. That's the field of the patent. And then if we scroll down further, you'll see item 56, the reference is cited. So these are the prior art that the examiner has cited. And we've also submitted some of the prior art. It continues on another page. And then below that, you're going to see the primary examiner. So this is Mr. Scott Medway that Mr. Turner had indicated required some discussion before we get allowance. And then, of course, the attorney agent, that's us, PatentPC, and my name is the attorney of record. So on the front page, you're going to see an abstract, and it says it has 21 claims and 3 drawing sheets, and it pulls out a representative drawing of the patent on the front page. So with that, what we'll do is we'll scroll down, and we'll see here, this is the continuation of the reference citation page. And now we go into an important part of the application. It is called the drawings. So the drawings, you'll notice that there will be the drawing plus identifying numbers. We call them reference signs. These reference signs will be discussed in the text, and so the numbers and the text correlate together, so that way when you read it and compare a drawing, you will understand better what how the invention operates. So here you'll see that there are 5 figures in the first page, sheet 1, and then in sheet 2 there are 2 more that explain how the devices interoperate. And then figure 3 shows the entirety of the device fitted over a breast and then collecting that, going ultimately through a control device that controls the pump. And then the milk is then collected into the milk bottle. So now going next, you're going to see the breast shield, the text of the breast shield with suckling motion one-way valve. And you'll briefly see a technical feel of the invention, the background of the invention, and a summary of the invention. The background is supposed to be providing a reader with the need for the invention, but it should not go into the invention itself. That is reserved for the rest of the application, starting with the brief summary of the invention. So the brief summary of the invention should be a highlight of what the invention is about. So we typically take claim 1 and we re-summarize that here as the brief summary of the invention. And that paragraph is also used as the abstract. The brief summary of the invention is similar to the abstract and is similar to the claim, so that the accused infringer cannot argue that the claims don't control. That's the reason why we typically make the summary consistent with the claim, because the claims are infringe, not the summary or the abstract. Next, we'll see on column 3 different variations in implementations of the invention. And then after that is called the brief description of the drawing, and here there's a one-line description of each drawings, and then you go into the detailed description. And here you'll see that the elements are mentioned in here. So the reference sign, as we discussed earlier, they're all listed in here, and then there's a description of how the reference signs describe the operation of the invention and how they interrelate so that the description is clear. And so the objective is to be clear to the reader. We'll have various alternative embodiments mentioned, and that's for the reason that we may have multiple ways of implementing the invention. So we want to list them all. And then in the end, what you're going to see is basically the claims. On column 11, claim 1 is stated here. So this is what an accused infringer, they need to implement every step of claim 1 in order to infringe claim 1. And then there's a series of dependencies. And the dependency further elaborate on claim 1. So it's the invention of claim 1 plus where in the one-way duckbill bivalve is a plastic material. And you'll see variations of that in the various dependent claim. Claim 1 is an apparatus claim because it covers the device. Claim 12 is a method claim. And so we can have dual nature of claiming the apparatus as well as how to use it. And so in this case, we have claims 1 through 11 would be the apparatus, and claim 12 through 21 would be the method. And that's it. That's a quick overview of the invention, of the patent application. If you have any questions, feel free to contact us. Thank you.